All right, guys, I want to welcome everybody. It is that time of the month for our monthly work comp. Today, I can't believe it's late June. We're already at the July 4th week. Dave, how you doing these days? You're all dressed up. Did you go courting today?
I'm doing well, and I actually had court today in person. Otherwise, I would have taken this tie and button down off and just put on a golf shirt. But yeah, I was actually in court in person. I had it, and I have a suit on.
Very good, very good. I want to welcome our guest, Alex Dell, out of New York with offices in Florida as well. Alex, thank you for joining us. We really appreciate you putting up with the Nomberg brothers for the next 45 minutes talking about work comp matters. How's your world?
Good. Glad to be with you guys. I got to tell you, though, I think sometimes my argument or what I say sounds better when I got a tie and shirt on. So that's why I did. Otherwise, I would have been here with a tank top on for you guys today.
You know, it's funny you say that. Oh, hold on, guys. I'm sorry. Let's see. Amateur hour here. David sometimes at home puts on a suit and tie so he can win some arguments with the three women in his world, but I'm not so sure his win-loss record is any better there than it is anywhere else.
I wish it would help, but it doesn't.
No, it does not. Well, guys, what we do every month is we pick the timely topics. What's going on in the work comp world? Dave has a great alternate name for our program. It's Work Comp for Nerds, because this is when we get to share our experiences. It's time where we get to share some of our insight from our daily practices about what we do in our lawyering world. So what we've got is a series of articles that we're going to talk about. And with Alex being mainly out of New York and us in Alabama, we've got a series of articles that's what we're going to focus on this time. It's not often that we do that, but for this one, we are. And guys, let's go to the first article. This is out of New York, and the title is Failure to Disclose Prior Work-Related Injuries Proves Fatal for New York Workers' Claim for Continued Benefits. Now, Alex, before we jump into the article, I should say this. If your firm is involved in any of these articles, I should have cleared this with you ahead of time, and I'm sorry. Let us know if this is these matters specifically involve your firm or if they don't. But
well, you know, I mean, for sure. I mean, this probably goes without saying, but our clients never commit fraud. They never engage in any misrepresentation. So it's obviously somebody else.
Mm-hmm. Well, it is. You know, this article is very, very much as part of our practices. But one thing I failed to do, I said hello to Alex, but I didn't get Alex the opportunity, because I'm talking so much, to introduce himself and his practice and what he does. And I should have done that. Alex, I apologize. Please tell us about yourself and your practice and something good about what's going on in your world.
Sure. Well, great. And again, thanks for having me, guys. And basically for the last 27 years now, I eat, breathe, and sleep workers' comp and disability law in New York, and then most recently in the state of Florida as well. And if you can believe it, I enjoy it as well. And our practice focuses on workers' comp, disability retirement, Social Security disability, and Veterans Affairs claims. And we'll represent people throughout New York State and in the state of Florida with these particular claims. We've got two offices in New York and one based in Florida, in Sarasota, Florida. And I didn't tell you this in the beginning because I wanted you guys to like me, but I used to be a Division I hockey ref and an NHL trainee for 2 years. So basically what happened was I wasn't getting yelled at enough as a lawyer or by my wife, so I had to go ref hockey games to feel loved and appreciated. But I got to tell you, it's been a tremendous segue for me, because the way lawyers get in trouble is kind of the way referees got in trouble on the ice. You know, they would be fixated on the front of the net. Meanwhile, somebody would get hit over the head with a stick behind the play and you didn't see it. And it's the same way an injured worker looks at these things. They think, oh, I got hurt at work. I simply have a workers' comp claim. And they fail to realize that if they continue on with their disability, now they've got a Social Security disability claim. Maybe they've got a third-party action. So I think one of the things that is really important is to really accept the idea that when you're representing an individual, you're not necessarily representing that one particular claim, especially in this field of law. I mean, you may get away with that if you're representing someone criminally or in a real estate matter, but when it comes to these areas, I mean, you guys know you really got to avoid tunnel vision and try to look at all aspects of how you can help somebody.
You make a great point, Alex. And the way we look at it in Alabama is there's such a limited recovery for our clients through the workers' compensation system that we're always looking for additional avenues of recovery to help them get their lives back on track. So that's an excellent point you made.
So, yeah. So with that said, too, I mean, jumping into this first topic, I mean, this law in New York State, which is actually Section 114A of the workers' comp law, came into play when they did some reforms in 1996. So essentially like 26 years ago. And I'm sure you can relate to this. I mean, back then, if we had 1,000 claims going at once, maybe in one or two of them, somebody on behalf of the carrier employer side would say, hey, your client committed fraud or they made a misrepresentation. Now we hear that word every single day. And I got to tell you, I mean, I think it's blown out of proportion. There's a few defense lawyers that I'd like to buy The Boy Who Cried Wolf for and give them that book for Christmas. But it's a problem. And New York is very strict on this particular issue. I think a lot of times people forget that you need to look at the statute literally. And in order to constitute a violation, there's got to be a material misrepresentation in order to get workers' comp benefits. And that's not always easy to prove. The problem is that the board has taken a very liberal view of what they consider to be fraud or misrepresentation, or, for example, omissions. I think people fail to realize that simply because you said nothing means that you didn't commit some type of misrepresentation. A lot of times that's more problematic. But the way the law is set up in New York is that there's two components to it. There's what we would refer to as a mandatory penalty and a discretionary penalty. The mandatory penalty pertains to the actual period in which the misrepresentation takes place. So if you said you weren't working from X date to Y date, and they found that you were, and that you misrepresented your situation, then you'd be disqualified for benefits for that particular period. However, in order to determine whether you would be permanently disqualified, the board would have to look at this discretionary penalty and basically determine that your behavior was so egregious, so outlandish, and there were not mitigating factors such that they would permanently disqualify you. And the trend in New York is if we get you on a mandatory penalty, we're generally going to try to nail you as well on the discretionary penalty. And a lot of times, that's where the good litigation comes into play, where the board made a leap to say, hey, this was so bad that we should permanently disqualify you. So we've really focused on that, especially at the appellate level, trying to see whether we can undo a negative finding in that regard.
Dave, let me ask you if it makes a difference. In this matter, the claimant testified he thought those accidents were old or occurred too long ago to be considered important. And he further testified that he did not think he needed to mention the prior injuries or awards because they were already in the system. That's what the facts that they disclosed here in this article. If in Alabama, the workers never asked about prior claims, of course they're going to be, but if they're never asked, do they have a proactive responsibility to disclose them? And in comparison to that, what happens if you just flat out lie and deny it and then it's found?
A lot of times we see this on an employment application, or our clients will see it on an employment application where they'll be asked about prior work accidents or prior injuries, things like that. And if they don't tell the truth, if they don't include something, then the employer could use that as a defense to their work comp claim or as a reason to deny their work comp claim. It is an affirmative defense, misrepresentation on an employment application. The Alabama law is very specific, though, as to what the employer has to put on the application in order for there to be a viable defense. There's some specific language that the Alabama Work Comp Act requires of the employer to put on that application. And we've seen that before in cases pretty frequently. I've got a question for Alex. It was, you probably don't know whether this gentleman was represented at the time that he was filling out this work comp form, but does some of this fall on his lawyer, assuming he had a lawyer at the time? Isn't the lawyer, doesn't the lawyer need to go back and look for these things to make sure that the application is done correctly?
Yeah, no doubt, Dave. And, it's interesting. A few years ago, the Workers' Comp Board added to a claim form the question, do you recall having a similar illness or injury? Very challenging, dangerous question. So sometimes we leave that blank. Sometimes we check yes, and sometimes we check no. I mean, obviously, the other issue is the lawyers are supposed to certify that claim for compensation that gets filed with the board. And there are some cases where people just didn't think that it was a big deal or it wasn't something they recalled at the time. But the reality is it's better to err on the side of saying, yeah, you know what, I did sprain my toe 30 years ago. And then let someone else say, all right, you know what, no big deal, let's move on. But there is definitely, I think, a responsibility of the lawyer to be involved. And, a lot of states, I mean, New York included, have tremendous resources where you can literally find out about people's prior claims, even where they have no recall. And so one of the things we do as a routine matter is we'll get a special authorization form that will allow us to speak to the board and get every single case number they ever had. Because, I mean, I think in general, sometimes people are not the best historians, but it's a dangerous question. And I've never seen the question, this is interesting, used for the benefit of the claimant. It's always used to nail them. And that's a real issue. In fact, in our intake paperwork that we send people, we specifically point out, please pay particular attention to this question. There could be issues of misrepresentation or fraud raised. But, I think the whole issue is problematic. And a lot of times when you get into these misrepresentations, especially when you get somebody working under the table, a lot of it is really ignorance. I mean, I don't think a lot of people are truly intentionally doing it. You take the construction worker who used to make $1,500 a week and now he can't. And now somebody pays him $500 a week under the table. And he says, you know what, I'm not going to say anything because I don't think I should because I'm not paying tax on it. Meanwhile, if we brought that to the attention of the Workers' Comp Board in New York, we would say, okay, you used to make $1,500 a week. Now you're making $500. You're losing $1,000 a week. And guess what? You get 2/3 of the difference. But because he fails to disclose it, now it's, hey, we're going to cut you off. But the interesting thing, one more thing I wanted to mention about fraud in New York is that even with that finding, the medical remains open in New York. There's an appellate case that allows that to occur. Whereas in Florida, if they get you on fraud, you're done completely. Yeah.
Well, fellas, let's put that one to rest for now, and let's come back. Let's come to our next one. And Dave, this is an old case, but it's from the state of Alabama, and the title is Lightning Strikes Elementary School Coach as he sits in his office, not out on the sports field, but does this man, would work comp apply to his situation?
No. I think that if he made a claim for workers' compensation benefits after being struck by lightning while in his office, even though he's at work, even though he's on the clock doing his duties, I think there is what's called an act of God defense to this claim. In other words, he's entitled to no workers' compensation benefits because it is an act of God being struck by lightning.
Just because it happens at work doesn't necessarily mean that it's a compensable claim. And the thought there being is he could be sitting at home. He could be sitting in his car driving an errand. But let me take it one step further. He gets hit by, or the lightning knocks out the school's telephones or whatever it does. And then he's walking away from where he was sitting or standing where he was struck, but a window blows out and it injures him. or he trips over his desk or something as he's leaving that space because he just got hit, could that then turn it into, and I know I'm playing with the facts here, but could that then turn it into something compensable?
I'm going to start with your first hypothetical, or one, I don't know if it's the first one, but you said something about tripping over the desk. I guess it depends on what he's doing and where he's going.
Mm-hmm.
That is possibly still covered by work comp. I think you mentioned shattered glass. Say lightning hits the building, shatters glass, and injures him. I still think that's going to fall under act of God and not be compensable.
Alex, let's take it to New York or Florida, your choice, since you guys practice in both. Is there an act of God defense? Is there something that would take this outside of being compensable?
Well, let me start by saying that if God forbid that happened to one of us, I would hope that we were sitting in an office in New York or a school in New York and not in Florida. New York actually has a presumption of compensability under Section 21, which basically says if something happens in the course of your employment, it's presumed to have arisen out of your employment. And so that same presumption does not apply, for example, in Florida. But I would say to you that there's probably a greater likelihood of success in New York on that particular claim. I think what comes into play are elements of risks, being put in a certain zone of danger, being put in a certain environment because of your workplace. And I think that would be the angle or the strategy to try to demonstrate that should be a compensable event. And similarly, I think, when you start talking about a pane of glass hitting someone or tripping over a desk or a chair, those are items that are created because of the work environment. Mm-hmm. And I would contrast that from a syncopal event or an idiopathic event. And I would say that those have a greater likelihood of being compensable than, for example, a syncopal event.
One of the terms I know that perked up David's ears that you said was presumption. Dave, how does Alabama treat any type of presumption when it comes to Alabama law?
Doesn't exist. Thanks, Alex.
He's not rubbing it in. He's just telling he lives in a much more progressive state when it comes to work comp and many other things. But let's move on, fellas, to the next article. And again, we're going to stay in Alabama for this one. And this comes up in more and more of our cases where it says the comp carrier cannot subrogate against uninsured motorist compensation received by the worker. Dave, before we get into the article, define briefly what is uninsured motorist compensation. What is that talking about?
Sure. So when you have auto insurance and you have the option to have what's called uninsured or underinsured motorist coverage. And that is insurance money that will compensate you if you are injured while operating your car or in your car or near your car. And there's an injury caused by a third party or a tortfeasor, but that tortfeasor or third party doesn't have enough insurance or doesn't have any insurance that will compensate you. So you can have uninsured or underinsured coverage through your own auto policy.
And
please get it. Please get it. Please get as much uninsured or underinsured coverage as you can. Please. It's needed.
Absolutely. Now, Alex, does this operate the same way in New York? Do you have underinsured, uninsured coverage? We kind of put those together because they're typically sold in the same policy or the same part of the auto policy. Does it operate the same way or similarly in New York?
Yes, and the case law is well established on this point. In fact, the workers' comp carrier in those cases doesn't have any consent rights. They have no lien rights, no offset rights. So, in the right cases, it can be really, really important. And I would say, Dave, just what you said, to get as much of that coverage as you can. And, it's interesting. I was talking to an insurance broker one day, and I said, what's the difference in cost and premium between, for example, having $100,000 worth of coverage versus 300, and it was literally just a few bucks. And I said, how come nobody knows that? And the answer was, well, now. And it's something worth talking about because, nowadays people are running around either with no insurance or just the state minimums, and you get in a real bad wreck. It's a good idea to have that coverage in play.
Alex, less than 50, I think about 15 years ago in Alabama, you didn't have to have any type of auto coverage. They finally changed the law, modernized it a little bit, but just getting people over that hump, much less learning about the other types of coverages and why they need them. We try to educate every time we can and as often as we can. And it's quite valuable. Sometimes there's very little coverage or no coverage in just a straight automobile claim. But I really think this helps our clients so much in these situations when they have them. And we don't have to spend a lot of time on this article, other than I wanted to bring it up just so, again, we could talk about it. Hopefully people who are watching this or listening to us talk about these cases will then look at their own policies and hopefully purchase pretty cheap coverages that can be quite valuable. Fellas, let's move on to our next article. And we're going to come back to New York. Worker gets summary judgment for shower curtain rod mishap. Alex, had this case or situation made it across your radar screen before we chose these articles? Are you familiar with this one a little bit?
Well, it's a common area of concern in New York. I mean, in many states, I mean, if you have somebody who gets hurt at work and then there's potential third-party liability, New York enjoys some statutes that provide absolute liability, particularly, if we have a gravity injury or there's a violation of a commercial code. So, this type of situation obviously calls into question, is there third-party liability? And, obviously you're always looking to try to get to a point where you can get summary judgment and then just get to the issue of damages. But I think this case, highlights the significance of the fact that when questions of fact get raised, you're not necessarily going to get to that point. But there's some pretty powerful statutes. And I think what you have to do is you have to get into the weeds, especially what we refer to as 241 subdivision 6 in New York, which deals with the labor law. Because you can have cases. We had one where an individual was working for Sodexo at a university and he fell off a loading dock. And it turned out that the commercial code said that if you got a loading dock and it's over 4 feet high, you got to have a rail on it. And if you don't have a rail, you're dealing with absolute liability. It turned out that individual suffered a horrific traumatic brain injury. And so they couldn't contest liability because they didn't meet the commercial code. So.
Dave, does any of this fact pattern here, if this were to occur in our state, it's because our laws are so different on many of these issues. Is there anything from a practitioner standpoint to share with our potential clients or current clients about this fact pattern that would be of help?
One thing that stood out to me was that if we filed this case, the employer might try to defend it with willful misconduct. Mm-hmm. That our client should not have been up on I think you said a bathtub railing trying to install the shower curtain, that he did something that was dangerous, that he known that was dangerous to put himself in that position. I think that would likely fail. Mm-hmm. But we might see something like that in Alabama is try to defend this.
Yeah, I think it would cloud the issues, Alex, and make our job a little bit, another hurdle we'd have to get over. But David, I agree with you. But go ahead, Alex. I didn't mean to.
Yeah, I was just going to say too. I mean, in New York, there's definitely challenges to the statute, and the term that comes up is that the worker was recalcitrant, right? Basically not cooperative. They did something that shouldn't have been done. They were told to wear a harness. They didn't wear a harness, or they improperly, shored something up. These are the things that are trying to be done to undo the absolute liability here. But It's a very powerful statute. I mean, it's something that comes up regularly in the New York legislature to have it undone, but so far they haven't been able to do that yet.
David, for your knowledge, I looked up recalcitrant, awesome word, having an ostensibly uncooperative attitude toward authority or discipline, otherwise also see teenager.
I was going to say, I've got some recalcitrant kids.
An SAT word.
That's right. Yeah. That's right. Well, fellas,
but that doesn't matter anymore, though. I thought the SATs don't matter anymore.
And a lot of schools are going completely away from all of that. But I want to welcome anybody who's watching this now or may catch us later. We've got Alex Dell from New York and Florida on our show, Work Comp Today. It's our monthly program where Dave and I just get nerdy about work comp matters. Dave, before we hit this last article, because all three of us are proud WILG members and going to different seminars and conferences, in different parts of the country, I want you to give, it's our time for a little plug for our organization, if you will.
Yeah, sure. So that's how we know Alex. We're members of WILG, the Workers Injury Law Advocacy Group. It's a nationwide group of lawyers who represent injured workers, both in work comp cases, in Social Security disability cases, and then Longshore and Defense-Based Act as well. So we have lawyers from all over the country, every state, about 1,000 members nationwide. And it's a great resource for us, and it allows us to meet great work comp lawyers from around the country like Alex.
Alex, if you've been to these conferences, do you get a lot of networking done while you're at them?
Yeah, I think they're great. I mean, first of all, listening about what other guys are doing in different states and how different states are interpreting different issues. And, lo and behold, these same things creep into your state before you know it. And so it's good to get a heads up on what's going on. Sometimes you say to yourself, well, I'm glad I'm not in that state. But then again, you never know. Tomorrow may be a new day.
Like today.
Tomorrow may be a new day. But yeah, it's just a great, incredible organization, and they've got some great speakers. And I'm just privileged to be a part of it.
I'm always amazed listening to just some brilliant minds in the world of work comp and lawyers, and some of the most generous with their knowledge and experience. And there's not a rivalry at these. It really is very congenial, and it's a great way to just learn more about how to practice law. But we'll pause the WILG conversation for now. Let's head into our last article that we've pulled. We're back in New York. Court revives part of labor law claim over workers' alleged fall at fish market. Alex, why don't you take the lead on this, and we'll chime in.
So an interesting case. I mean, I think it goes back to what I talked about earlier, where you have somebody who gets hurt at work, working for a very specific entity, and then claims that the place where they were injured should bear responsibility for the injuries from a third party perspective. And then, as you guys know, I mean, that's primarily done to try to get awards for pain and suffering and other benefits that you wouldn't otherwise get through the comp system, which is generally going to be limited to medical and indemnity or lost wages. And, this is yet another example where an individual claimed that they should have the absolute liability protection of the labor law section 240, and then also raised some commercial code violations under that 241.6. And what happens routinely in these cases, you deal with a lot of motion practice. You're always trying to say, nope, you're not entitled to this, this motion will be defeated. And that's exactly what happened here. I mean, the judge originally granted summary judgment dismissing the commercial code violations, and the appellate division, which is the second highest court in New York, said, you know what, there's still some triable issues of fact here. We really need to get to the bottom of what happened here and whether they did commit some violations of the commercial code. So, it's a constant issue. And usually what happens after you get through the motion practice is if these claims survive summary judgment, you're looking to generally settle the claims at that point. I mean, not as many of those are going to trial, but up until that point, you're going to live and die as to what happens on motion terms.
Dave, let's talk about motion practice with this case in mind. It's not often that we have to face the summary judgment issue. And I think part of that just comes from our experience about deciding which cases are worth fighting over in court. But if you survive a summary judgment in Alabama, what's the path? Where do you head after you survive that summary judgment motion?
As far as the workers' compensation case?
Yeah. Just in the context of work comp.
I think there's one of two ways you're going at that point. You're either going to have what we call a public trial to determine whether the claim is compensable or not. And because we have bifurcated hearings, Alex, first deciding compensability and then second one deciding disability, we typically don't see as many motions for summary judgment anymore. The defense would just rather have that first trial, to have the judge determine compensability. So if we win the summary judgment motion or win the compensability trial, then that sets us up for the second trial, which would be just to determine the degree of disability from 1 to 100%.
Anything else of substance from either of you fellas about this particular article or set of facts in this case that may be worth sharing?
It goes back to what we talked about earlier, where you're looking for other avenues of recovery for the injured worker. Again, I harp on it all the time, but we have limited recoveries for our clients in Alabama. So we're always looking for another avenue of recovery. Here's a perfect example of a business owner, a property owner, potentially creating a negligent situation, a hazardous situation for this injured worker. So he's got both a work comp claim and, as Alex mentioned, a potential third-party case against the property owner, where he could possibly recover damages, money for pain and suffering, emotional stress, lost wages, etc.
All right. I think that's going to wrap up our articles for this episode. But what we also like to do, Alex, is, and this is where David and I really are at a disadvantage in Alabama, when we learn of our guests' home state processes, policies, procedures, and statutory laws, how they treat certain things in the work comp context. So I want to take a couple of different things and let us just kind of compare how they do things in New York versus how we do things in Alabama. And the first thing is the definition, and I'm going to let Dave go first on this one. Dave, what's the definition of average weekly wage, and why is it important to know what it is for our clients, our injured workers who we represent?
Sure. So the average weekly wage is the employee's wages in the 52 weeks before he or she got hurt, divided by 52. Now, it's not for every employer that they've worked for in the 52 weeks before the accident. It's just the wages that they earned for that employer in the 52 weeks before they got hurt. So, for instance, if the injured worker received $52,000 in wages in the year before he or she got hurt, then you would take that and divide by 52, and the average weekly wage is $1,000. Now, here's why it's important for workers' compensation, because the average weekly wage, to determine their compensation rate, or how much they're paid while they're off work recovering from their accident, their compensation rate is 66 2/3 of the average weekly wage.
Alex, does any of that resonate in New York? Is any of that close to how you guys determine or need to know that information?
Yes, but I'm going to get on my soapbox just for a moment about this and say this. And I will tell you, in my opinion, in my practice, I think the single most important thing we do is making certain we've got the average weekly wage right, and never to assume that the carrier properly calculated your earnings for the 52 weeks prior to the accident. And like New York, we also use a 52-week amount of time to look at for person's earnings. If they had more than one job, we'll look at their covered concurrent employment, add that on top of their injury employment wages.
Oh, time out. Did you just say multiple employments can be factored into this?
Yes.
David, what do you think about that?
Next.
Keep going, Alex. Of course.
Well, I don't want you to feel terrible. I mean, if you don't have a covered job, if you're working for the federal government or you're with the National Guard or you're an independent contractor, those are out. But if you get a W-2 from another company, you're generally going to be covered. And
Wow.
we take, 2/3 of the average weekly wage, and that is what someone would get if they're considered temporarily totally disabled. The interesting thing in New York is the maximum rate. So for 15 years, between 1992 and 2007, the max rate was $400 a week. So use your example. If you were making $1,000 a week, 2/3 of that obviously would be well more than 400. You'd be limited to 400 a week. Then what happened in 2007 is the legislature said, well, each year we're going to increase that now. And so just to give you an idea, it went from 400 as of July 1st, and then July 1st, 2007, it went to 500. Now, as of tomorrow, which is July 1st, 2022, the new max rate is 1,125.46. So basically, you get someone who's making around 1,600 or so per week in gross wages. They're going to get that max rate, which is a big deal compared to before. Because a lot of people will say when they get hurt, oh, this is an old injury. Well, nowadays, you don't want it to be an old injury. You don't want it to be based on an old claim because you want to get paid more than double what you would have gotten paid back in 2006.
Dave, I haven't looked at ours. Also changes tomorrow. Dave, have you looked at the new max rate? I think we're not that far behind.
No,
we just did.
We're pushing up against $1,000. I think is the right. So
Oh yeah,
1,000. Yeah. We may just under or just at. Yeah.
Well, and the last part about this, the AWW. Alex, what if you have an employee who hasn't been employed 52 weeks prior to being hurt? How do they determine what the average weekly wage is for that particular situation?
So section 14.3 of the comp law, this is the stuff I got to memorize, says that if you didn't work substantially the whole year, we look at the payroll of someone who we would call a similar worker. You got to be careful with those, though, because I don't know what it is, but it always seems like the similar worker payroll we get is the worst worker in the plant, and they didn't even do what you did, and they don't even have the same job class as you, and somehow they made 10 grand less than you, and they and they worked the full year, and you didn't. But what's to be really careful about are the people that get big job changes midstream, mid-year. You get someone who went from a part-time nurse to a full-time nurse 26 weeks into it. What you got to be careful about is taking those wages and dividing by 52. What we do is we say, hey, you know what? This person was a full-time nurse when they got hurt. I want to see the wages of a full-time nurse for the whole year before they got hurt.
Dave, ours is pretty similar, isn't it?
That's right. Yeah. Similarly situated employee. And you're right, Alex, you've got to be careful and make sure our clients aren't getting taken advantage of by the employer who's putting out some information that reduces their average weekly wage.
All right, let's move on to the second comparison. Alex, talk about, is there such a thing as lifetime medical in a work comp claim in New York? What does that mean? Anything?
The answer is yes. And when somebody gets hurt in the course of their employment, they are entitled to ongoing causally related medical care. And that pertains to them regardless of whether they keep working for that particular employer or not. And it can be a lifetime benefit for them. What New York has done starting in 2010 is they've got some medical treatment guidelines now. And their goal is to basically cover every part of your body with these evidence-based treatment guidelines that basically pre-authorize certain care. So, with that proviso, people get care. And certain more significant treatment, fusions, spinal cord stimulators, they're going to need prior authorization for that. But as a general matter, they're going to have lifetime medical care, and they're not going to have to make any co-payments, premiums, deductibles, nothing. It's $1 coverage.
And Dave, I know we have lifetime medicals, but what happens 1 year, 5 year, 10 year, 15 years after our client's claim has been resolved? What typically happens at that point along the post-settlement time?
Well, a couple of different things happen. Number one, the work comp carrier is going to be very interested in coming back and trying to close out or settle the medical benefits. But as to our clients, the further our client gets removed from the actual original work accident date, the harder it is for that client to prove that the symptoms or illnesses or injuries are related to that accident. So when our clients settle with open medical benefits, we stress to our clients how important it is that they go see their authorized treating physician on an annual basis. That way, there's not this huge gap in time from their last treatment to when they want to go back and see the doctor.
And that's even if they're asymptomatic. We still, Alex, we want them to go at least once a year just to check in. So it helps to establish a pattern. And but it's still, as you know, both of you guys know, it just takes one adjuster to say, I want to cut off the bleeding here. Let's throw a wrench into this one and see what we can get done.
But that's great advice, though, because if you get somebody who then has an exacerbation a few years out and they hadn't treated, I think you minimize the argument that they had a new accident or a new trauma, and somehow now there's a break in the causal link. So I really like that idea.
All right, fellas, let's move into the last one. And I'm going to start with you, Alex. With your history of being involved in the world of hockey, have you had a lot of experience representing hockey players or refs or coaches who've been hurt in the line and scope of their job, and then it's resulted in a PTD, a permanent and total disability claim?
So yeah, generally with those athletes, they're not getting to that level. We're privileged now to represent a lot of the National Hockey League refs when they get hurt nationwide. A lot of those claims end up in New York because of the NHL having their principal place of business in New York. But those guys aren't going to tell you they're hurt until they're really hurt and can't ref, because they don't want to get pulled off the Islander Ranger game or the Chicago Blackhawk game against the Toronto Maple Leafs. So they don't tell you they're hurt until their career's over. But, permanent total in New York's an interesting concept, and it became much more significant after March of 2007. And the reason for that is before that date, if somebody had a permanent partial disability, they would get paid for life. And then the legislature changed the law and said, if you got a permanent partial disability, you're going to get a capped or limited benefit. It's going to be for a certain number of years, depending on your loss of wage earning capacity. So the only way to really get to a lifetime benefit now in New York is either to prove a medical permanent total disability or to prove a total industrial disability. Basically, guys medically partially disabled, but given their age, education, and experience, they're really unemployable. So very difficult standard. Nobody concedes anything on that in New York. We're fighting tooth and nail on that. We're generally dealing with some surveillance to try to disprove permanent total, but the reward is a lifetime tax-free workers' comp benefit.
David, hockey is a sport played on the ice, and they wear skates and they have a stick. And much like the sport you love, they get to hit each other. So I wanted to just preface that. I did a little research. It's not well known of a sport in the Deep South, particularly in the land of football, Alex, where college football, as you know, is king around here. But Dave, let's put it in a context that you will be able to relate to. A construction worker, a coal miner, a truck driver. What does PTD, what does permanent and total mean in Alabama's work comp world?
So it's the injured worker's inability to perform their job or a similar job, and the inability to be gainfully employed, which means they can't find a similar paying job. They can't earn similar remuneration. So I know Alex threw out recalcitrant earlier. I'm throwing out remuneration, get you some of that. But Alex, in Alabama, it's permanent total disability doesn't mean they don't have to be catastrophically injured. They don't have to be paralyzed. They don't have to be bedridden. So the standard is they just can't go back to that coal mining job, and they can't earn a similar wage to what they were earning as a coal miner. In other words, you can't just put them back as a Walmart greeter and say, look, you're employed, therefore you're not permanently totally disabled. It doesn't work that way.
Which is a nice statute. I mean, New York, it's, either all or nothing. You can't work at all. Now, there is a statutory permanent total. If you have a loss of 2 or more limbs, then you can be a statutory permanent total and still work. But it's a tough standard to meet in New York.
Well, fellas, we've gotten to the end of our itinerary for today. And before we wrap it up and send everybody off on a hopefully very safe and fun holiday weekend, first of all, I want to thank you both for going through the articles. Dave, I hope I wasn't too tough on you this week. I don't want to get a call from Mom, who's maybe one of our only watchers live right now. But we also want to thank Alex for putting up with us and spending some time and sharing your expertise and your experience in work comp, particularly out of New York and a little bit out of Florida. So thank you, Alex. We appreciate it.
You're welcome. Yeah, it's a pleasure to be here. Do I have a minute for one quick funny story, hockey story, lawyer story?
We're going to give you at least 4 minutes of time. Go.
G-rated, just so you know. So it was one of those days where all the lawyers were miserable, all the judges were miserable, even the clients really weren't that happy. And that night I was actually picked to referee a final hockey game. It was going to decide who was going to go to the Division I NCAA finals. And I was at Cornell University in New York. And if you've ever seen or heard of a hockey game, it might be one of the best places in the country to see a college hockey game. But to make a long story short, there was a game-winning controversial goal for the visiting team. And I ruled that it was a good goal. And consequently, I had about 4,000 Cornell fans, Ivy League fans that were ready to kill me that thought I made the wrong decision. Well, turns out I made the right decision, but there was a blizzard that night and I had to drive from the middle of New York State back to Albany, New York. And normally it's like a 2-hour and 45-minute ride. That night it took about 8 hours to get back with the snow, which I know you guys see all the time in Alabama. And I get home, I go in my bedroom at 3 a.m. and my wife wakes up and she said, Alex, is that you? And I said, yeah, it's me. And I was really dejected. I was just really looking for a little support. And I thought my wife would be the one person who could love me and tell me that. And she said, how was your day? And I said, it was terrible. I told her all the things I told you guys. And then there was this weird pause. And she said, if you really wanted people to like you, Alex, you picked the 2 worst jobs in America. And I said, thanks, Tina. And I said, good night, Tina. And she said, good night, Alex. And we both went our separate ways and went to bed. And I woke up and I'm still reffing and having, I'm not reffing anymore. I didn't want to take a puck in the mouth, but I'm still having fun being a lawyer and beating up defense lawyers.
And that's why we do the work we do. It's that passion. It's you want to help those who are most in need. Because, Alex, we all know that when our clients get hurt and they're calling, reaching out to us, it's one of the most stressful times of their life because their health, their wealth, and the communication within the family dynamics is all thrown for a haywire. But one last thing before we sign off. Dave, what happens if we even get a hint? What if James Spann says we're going to get a 1/4 inch of snow in mid-state Alabama? What happens in our world?
Alex, it is shut down, man. We, first off, everybody runs to the grocery store and buys milk and bread. Don't know why, but people go buy milk and bread, and, even the threat of snow can shut down businesses, schools close, and you just stay home.
We have no infrastructure to deal with it. We have nothing to deal with it other than everybody gets to go home and stay home.
Anyway. Snow day.
That's right. Or snow week at times. Alex, thank you, bud, for spending some time with us on Work Comp today. We've really enjoyed our time with you. And and running through these articles and doing some comparisons of our two respective states and how the laws operate.
Yep. Good seeing you guys, and thanks for having me. I'm sure we'll see you again soon. I hope everybody has a good, happy holiday too.
You too. Dave, any last parting words of wisdom?
Happy July 4th, everybody.